Title 42, the pandemic-era public health policy at the border that allowed the U.S. to turn away millions of asylum seekers, is coming to an end in a matter of hours now. Crowds of migrants are gathering at the border, waiting to apply as officials prepare for an influx of people. Immigration attorney Andrew Neater is here now to talk more about what comes next. And thank you so much for joining us.
Thank you for having me.
Well, let's start with Title 42. What is the immigration process under Title 42? What will it be under Title 8, which takes its place?
Okay. Well, I think it would surprise a lot of people to hear that Title 42 is not even an immigration law. It's a public health law that really allowed immigration officials to expel migrants coming to the border. It was part of an emergency order issued by the last administration. Many people thought it was a bit of a pretext for using this particular statute for immigration purposes, because it wasn't necessarily applied evenly to all different types of populations. But under Title 42, immigration officials could just expel somebody from the port of entry, from the border, even if they had a valid asylum claim.
So this is an opportunity for some people. That's how they view it, that this is a time they can really seek asylum. What's it like under Title 8, the process?
So Title 8, it will revert back to what has always been on the books as the immigration law. If somebody comes to a port of entry, they can be admitted to the United States, for instance, if they have a visa or a green card. If they don't, they'd be subject to what's called expedited removal, sort of this quick deportation. If they make a claim of asylum, then they would be given what's called a credible fear interview to evaluate whether their fear is valid. And if they pass that interview, the case would proceed to the next level, which is usually going to immigration court for a full adjudication of their claim.
We know the federal government had sent some National Guard troops down there for administrative purposes. We know that Border Patrol has been beefing up their staff. You're someone who's been in the immigration law community for some time. Should we expect that community, judges and immigration lawyers, that you're all beefing up as well, staffing to handle this influx?
There's definitely a beefing up within our local community, nonprofit organizations, volunteers, attorneys, and also those within the immigration court structure, if they get the proper funding from the federal government. But in our San Diego community, definitely people are preparing. They've been preparing for this. If you go down to the border, you can see the wonderful overflow of volunteers offering assistance, and those within the legal community are also standing by to see how we can help. We still need to get a little bit more clarity on exactly how the Title 8 is going to be implemented, but we're ready to help as much as we can.
And we know that politics often blinds this issue, and it's hard to tell what the truth is between some of the debating. But there is a concern that people ask for asylum, they're granted it, and then we just lose them into society, that they don't return for court dates. Or who is in charge of tracking individuals and bringing them from start to finish through this asylum process? Because it is years in the making.
It is years in the making because there's a backlog of a lot of cases in the immigration court. But when somebody is given the opportunity to come into the United States and they're given a court date, the Immigration Service has the discretion sometimes to keep that person detained or release them with monitoring or release them to families. But the statistics show that the vast majority of those that have court dates show up to those court dates, usually because they have regular check-ins. Sometimes they physically go to an ICE office. Sometimes they use an app.
And if they don't show up, what are the repercussions?
Well, if they don't show up, then they could be subject to an order of deportation, what's called in absentia, for not showing up. And then if they're detained, they would be deported from the United States with some serious consequences for the ability to come back in the future.
All right, so there's an incentive there. Let's talk real quickly, because we're running out of time, but as an immigration attorney, I've been asking everybody, because we're not seeing any kind of meaningful immigration reform coming from Congress and haven't in decades, what reforms do you think need to take place in order to avoid the situations like we're seeing now?
Right. Well, we haven't seen any significant change in the immigration law in about 40 years. So there really needs to be a shifting of priorities to give the resources to the immigration courts and the adjudicators so that we can process individuals fairly and efficiently, and not just throw billions of dollars into building walls and trenches, because we really need to find a way to fairly adjudicate these cases so that people with valid asylum claims can be processed in a reasonable amount of time.
All right, Andrew Neater, thank you so much for your time and expertise. We really do appreciate it.
Thank you.
All right, thank you.